All right, time for convening having arrived. The Senate will come to order. Would ask that unauthorized visitors exit the chamber at this time as the Senate is coming to order. It's my honor now to recognize the distinguished senator from the 53rd.
Good morning, Mr. Berg. Good afternoon, Mr. President. It's a cold day in the state of Georgia. It's been that way for a couple of days, but the members of the Senate is always eager to improve the quality of life for each and every Georgian. The journal's been read and found to be correct.
Thank you, Senator, for your good works on the journal. Is there objection dispensing with the reading of the journal? Reading of the journal is dispensed with. Is there objection to the confirmation of the journal? Chair hears none, and the journal is confirmed. All senators having bills and resolutions introduced, please bring them to the Secretary's desk at this time. Let me have the Senate's attention for a moment. As many of you witnessed earlier, that we have a new senator from the 17th District, and at this time we would like to seat the senator himself, and we are delighted to welcome today the senator from the 17th, and would ask the Secretary, so the Secretary of State has certified the election. Without objection, the senator from the 17th will be seated in the Senate. And ladies and gentlemen of the Senate, if you would please join me in congratulating our newest elected senator from the 17th. Thank you. Thank you. Thank you, Senator. First reading and reference of Senate bills and resolutions.
Senate Bill 323 by Senators Jackson II, Henson the 41st, Tate of the 38th. And notice the bill be titled Enactment, Article 3 of Chapter 5, Title 17 of the OCGA, relating to the disposition of property seized.
Public safety.
Senate Bill 324 by Senator Albers of the 56th, Beach of the 21st, and Thompson of the 14th. The bill be titled Enactment, Code Section.
Transportation.
Senate Bill 325 by Senators Kirkpatrick of the 32nd, Hostetler of the 52nd, Burke of the 11th, and others. Bill be titled Enactment, Chapter
Health
34.
and Human Services.
Senate Bill 326 by Senator James of the 35th, Red of the 33rd, Harbison of the 15th, and others. Bill be titled Enactment, Part 3 of Article 6 of Chapter 11, Title 15, Title 17.
Judiciary.
Senate Bill 327 by Senator Albers of the 56th and Harper of the 7th. The bill will be titled Enactment, Article 2 of Chapter 16 and Title 45 of the OCGA, relating to death and
Public safety.
Senate Bill 328 by Senator Albers of the 56th, Hostetler of the 52nd, Councilor of the 46th.
Finance.
Senate Resolution 587 by Senator McCune of the 29th, Gooch of the 51st.
Rules Committee.
Mr. President, the Senate has received the names of appointments to the Judicial Qualifications Commission that require Senate confirmation from the Governor, Lieutenant Governor,
Committee
Speaker of the
on
House.
Assignments.
Mr. President, that concludes the order.
It is now time for the morning roll call. Time for the morning roll call. Are there any motions to excuse? Chair recognizes the distinguished senator from Columbus, senator from the 15th.
Thank you, Mr. President. I'd like to ask unanimous consent that we excuse the senators from the 10th and the 2nd.
10th and the 2nd, is there objection? Without objection, the senators from the 10th and the 2nd will be excused. Are there any other motions? Chair recognizes senator from the 12th.
Unanimous excuse the senator from the 38th.
Just the 8th or? 38th. 38th, without objection, senator from 38th will be excused. Chair recognizes senator from the 40th.
Mr. President, I ask for unanimous consent to excuse the gentleman of the 13th.
13th, is there objection? Without objection, senator will be excused. Any other motions to excuse? Senators, please signify your presence by voting the A switch. The Secretary will unlock the machine. It is now time for our morning devotion. Time for our morning devotion. Would ask that all senators please take your seats and cease all audible conversation as we are beginning to prepare the chamber for our morning devotion. It is indeed an honor for me now to recognize the distinguished senator from the 44th District for the purpose of leading us in our pledge and introducing our chaplain of the day. Senator.
Would you please stand for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Now the Georgia flag.
I pledge allegiance to the Georgia flag, to the principles for which it stands, wisdom, justice, and moderation.
Thank you very much, Mr. President. Senators, it is my honor to present my pastor, the Reverend Donald Reed, the senior pastor of Andrews Chapel, United Methodist Church, Jonesboro, as chaplain of the day here in the Georgia State Senate. Reverend Reed is a gifted and dynamic teacher and preacher whose intellectual and thought-provoking sermons have informed, inspired, and uplifted people of all ages for over 30 years. Reverend Reed was born and reared in Covington, Georgia, in a spirit-filled home with his 5 siblings who were all loved and nurtured by his parents, James and Annie Reed. He received his primary and secondary education in the Newton County Public School System, where he achieved numerous academic honors until his graduation in 1976. 4 years later, in 1980, Reverend Reed earned a Bachelor of Science degree in mathematics with honors with a minor in speech communications from Georgia State University. While at Georgia State, he was involved in campus ministry, and he was a member of the Georgia State Gospel Choir. Additionally, in 1979, also while attending Georgia State, Reverend Reed accepted his call to ministry and became licensed to preach while in a mentoring relationship with the Reverend John W. Pace, who at that time was the senior pastor of Richards Chapel United Methodist in Covington, Reverend Reed's home church. Following college and after accepting his call to ministry, Reverend Reed entered Gammon Theological Seminary of the Interdenominational Theological Center to pursue a Master's of Divinity degree. While at ITC, he excelled in the Old Testament study and the Hebrew language and always remained in the top 10% of his class. He received first runner-up for the ITC's Preaching and Homiletics Award and was a nominee for the Benjamin E. Mays Fellow in 1983 and 84. Prior to graduating with honors from ITC in the spring of 1984, Reverend Reed began his ministry in the North Georgia Annual Conference in 1982 when he received his first pastoral appointment to Union Chapel United Methodist in Marietta, Georgia. With his many gifts and graces, Reverend Reed has led metro congregations including Calvary, Hoosier Memorial, Warren Memorial, and Cascade here in Atlanta, Golden United Methodist in Douglasville, and Columbia Drive United Methodist in Decatur. Reverend Reed and his lovely wife, Natalie, are parents to 5 children. He loves the Lord, his family, and all of God's people. It is his lifelong desire to transform the world through faith. Colleagues, I present this profound teacher who loves the Word of God and has the ability to bring the Word to life, the Reverend Donald Reed.
Lieutenant Governor Cable, senators and friends, it's a pleasure and an honor to be here. Now, I understand there's no singing here, but just know that I'm singing in my heart right now. Let me share with you this morning these words from the gospel recorded by St. Luke, chapter 10. But wanting to justify himself, he asked Jesus, "Who is my neighbor?" Jesus replied, "A man was going down to Jerusalem from Jericho and fell into the hands of robbers who stripped him, beat him, and went away, leaving him half dead. Now by chance a priest was going down the road, and when he saw him, he passed by on the other side. So likewise a Levite, when he came to the place, saw him, he passed by on the other side. But a Samaritan, while traveling, came near him, and when he saw him, moved with pity, he paused. He went to him, bandaged his wounds, poured oil on them, and put him on his animal, brought him to the inn, and took care of him. Jesus then asked the question, which of these three do you think was a neighbor to the man who fell into the hands of robbers? The man who asked the question said, the one who showed him mercy. And so Jesus said, go and do likewise. Good afternoon, friends. I want to thank you for the opportunity to share with you. This is my first time here in this capacity, and it is an honor. And I thank also my senator and my member, Senator Gail Davenport, for this invitation. These are crucial times in which we live. As we gather in these early days of this new year, 3 days after honoring the life and legacy, the works of Dr. Martin Luther King, Jr., a drum major for justice, equality, and peace, a Georgia son, we find ourselves in a new legislative season. What you will do, how you will address the many difficult issues that will come before you, I do not know. Perhaps you do not know just yet. But a quick perusal of the headlines reminds us of the challenges that we face. Racism is on the rise. There's a new administration that says that Klansmen and white supremacists are good people as well, and there's good in every man. The tragedy of sexism is being exposed as more than just locker room talk by the Me Too movement. We still do not know what we will do or how we will address or even what happened with the Russian hacking. We don't know. Our politics are more filled with tension than ever before. The vulgarity is unacceptable. I know that you do not take your job as leaders for this state lightly. You recognize more than any other the heavy burden of leadership that is thrust upon you. There surely are certain things that we don't know, how we will lead, what we will decide on the issues before us. However, there is one thing that we do know. I'm reminded of the words of the barefoot backwoods carpenter from the backside of Nazareth. He said, "Those to whom much is given, much is required." I am glad to be a native of Georgia and delighted to be able to stand before you. You will face tough issues, but you cannot remain silent on them. Silence is not an option. You will have to vote. You will have to speak. And when you do, I simply urge you to remember to speak for those who may not have a voice. Remember that you will lead us and we will pray for you. We'll undergird you and do our best so that you are successful, because as you are successful, Georgia is successful. But I urge you to heed the words of the carpenter from Nazareth. You are my neighbor, my brother, my sister, my friend, and be guided by his words today. Decide who you will be and what you will do. And in the words of Dr. King, be the best that you can be. We are better than the things that are going on around us, and I thank God for you. We are better than the xenophobia, the intolerance, the hate-filled speech of some, the sexism, the racism, and the division that some would like to bring before us. We are better than that, but we cannot be silent. Jesus said, "Those to whom much is given, much is required." Do this job. As one who has come to serve all the people, do this job. What is required to serve? Serve truth. Do not make up your own facts. And what is truth? Somewhere I heard we hold these truths to be self-evident, that all men are created equal. We are endowed by our Creator with certain inalienable rights. Serve truth. In an age of alternative facts, let truth be your guide. The poet said, truth on the scaffold, wrong on the throne, but God stands in the shadow and he keeps watch over his own. Serve truth. Serve justice with compassion. You're here to serve the good of all people as you have done in the past. Continue and do so in the future. When Dr. King wrote his letter from the Birmingham jail, he said, injustice anywhere is injustice, is a threat to justice everywhere. So be on the right side. Continue to be on the right side. You've done it before. Do not be swayed by what others do out there. Be guided by your faith, your conscience. Be on the side of truth, the side of justice, the side of equality, the side of peace and respect. Be on the side that builds up rather than tears down. This is not a time for silence. Silence is not an option. Some may seek to divide us, but because we are Georgia, we will be together. We will serve. We will pray for you. You have been given a great responsibility. My prayer is that you will meet the challenge of this decisive hour with righteousness and with compassion. Those to whom much is given, much is required. Let us pray. Gracious God, we come before you this day, giving you thanks for all of the blessings you poured out upon us. From the north to the south, the east to the west, we are your people. Lead and guide these great men and women as they deliberate to do their very best in leading this state. Pour out upon them mercy and compassion. Pour out upon them your spirit of truth and justice. And may all that they do bring glory and great, great honor, not only to this state and to this nation, but even to you. We ask this prayer in the name of him who created us all. Amen.
Are there any unanimous consents? Does any senator wish to rise on a point of personal privilege? Chair recognizes the minority leader, the senator from the 41st, on a point of personal privilege. Senators, please give the distinguished minority leader your attention.
Thank you, Mr. President, members of the Senate. I rise today with news, good news. You probably all have heard that we made another cut on the Amazon search for a new home for HQ2. And so this morning it came out that Atlanta is still in contention. And that's a very positive thing. As we go through this session, I think we need to make sure that we focus on things that will continue to enhance Georgia's business opportunity and growth. And many of those things have come out in this Amazon search. And the one that I wanted to bring to you today is transit. You know, we had a very good state of the state, but there were several things that were missing. And one of them is a true commitment of this state to back up those metropolitan counties like DeKalb and Fulton and others who have their bus systems and transit, started a statewide commitment to help those areas and help build a transit system we can be proud of. That's going to be important not only in bringing Amazon to Georgia, but bringing other businesses and retaining businesses that we have. Any of you that live in Atlanta or frequently go through the metropolitan area are now struck with the true damages on our daily life created by traffic jams and congestion. We're one of the worst cities in the country on that. And that is spreading out to other areas far outside the city of Atlanta. So I hope as we move forward, we continue to work in a bipartisan method to try to get monies directed toward transit and improving the outcomes of our transportation system. Mr. President, I'll yield the well if there's no question.
Chair recognizes Senator from the 21st on a point of personal privilege. Please, the Senator wants to pay tribute to a DOT member.
Mr. President, fellow senators, I rise today to congratulate GDOT for the great job they've done on this inclement weather, but also want to inform you that we had a death today. A GDOT employee was killed, hit by a train. We do not know all the details, but I would ask that we keep your thoughts and prayers with the family and with the GDOT family. It's a tough day for GDOT. Thank you. I yield the well.
Senator, before you leave, let's I think now would be very fitting for us to all rise in a moment of silence in our prayers for the family. Let's pray. Amen.
Thank you, Mr. President.
Thank you, Senator. Chair now recognizes Senator from the 36th on a point of personal privilege.
Thank you, Mr. President. Good afternoon, colleagues. Hope we're all managed to stay warm and get through this rough patch of ice. I take the well briefly to really, in a sense, follow the remarks that you just heard. We saw with great delight this morning early that Atlanta is included in the list of the 50, I guess, semifinalists, but the targets that Amazon will be looking at to build HQ2. It's very, very big news, enormous possibilities economically for our state and job creation. At the same time, in Washington, I want to caution those who are elected here and are sitting in Senate seats and House seats up in Washington, representing Georgia, to be very mindful of the things that you endorse, the things that you attack, the efforts that you may be making to go along with shutting down government or passing draconian anti-immigrant legislation or even loudly speaking about it. I mean, it just occurs to me that serious questions need to be posed to our elected congressional delegation, and in particular our junior senator, about whether he and they are going to give serious consideration to being a part of having Georgia as a welcoming environment, a welcoming state, room at the table for all, or going to go down the road of reactionary blocking and barricading and stripping 800,000 DACA recipients, the dreamers, of their status that has been accorded to them. When you take those kinds of positions up there in Washington, it can impact in many ways how we appear to the business community and to those who look to Georgia as a possible place to come and grow our job force and grow our economy. And I pose that question quite seriously. We have seen over these last 2 or 3 years when we get out on some thin ice with some legislation that is highly questionable, the business community, and I applaud them for it, has shared their concerns. Business wants to do business with everybody. A thriving economy is not built on separation and division and hate and the haves and the have-nots. It's built on building an economy that welcomes everyone and makes use of the talents of all of our people. The immigrant community, for example, is part of the backbone of the Georgia workforce, period, paragraph. You can ask the people that work in creating structures, construction, homes, residential and commercial, and they'll tell you who's playing a critical role in the workforce here in Georgia. Hard workers, good workers, faithful workers. Talk to people in South Georgia, and we've heard from our very own farmer members of this Senate chamber. When you take draconian measures against the immigrant community, you are impeding our workforce. You're sending a message to part of the backbone of Georgia's workforce that they're not welcome. And guess what? People pick up and leave our state, but they'll go to a state that is more welcoming. So I just caution our congressional delegation as these negotiations and the pace and the fervor of these negotiations in Washington and this threat of shutting down government, failing to reach agreements, et cetera, dragging out, for the Lord's sake, dragging out the reauthorizing the funding for the Peach Care for Kids, Children's Health Insurance Program. Take a look back home and think very seriously, are your actions in Washington the best reflection of our state? And are we putting out the doormat for business and economic development, or are we pulling up the rug and barring the door? Because we are being looked at quite seriously by major economic forces in the country as to where Georgia is going to be on the scale of being a welcoming state that employs, has full employment and a job for everyone. Thank you for your ear, and I look forward to future conversation about it. I look forward to hearing from some of those members of the congressional delegation about what they're doing, what's their contribution towards making us an attractive place. Thank you, Mr. President.
Thank you, Senator. And also, don't forget Apple as well, and the great expansion in which they're looking at, $30 billion, and they are bringing $250 billion back to the country, thanks to the good work of Washington, D.C. I also want the Senate to take a moment in joining me with a special guest that we have present with us, the son of the President Pro Tem, Mr. Charlie Miller, back in the back. Let's give him a round of applause. All right, Charlie, good to have you with us, buddy. Chair recognizes now the senator from the 50th.
Mr. President, members of the Senate, Franklin County and our state experienced a tremendous loss yesterday with the passing of Mrs. Betty Russell Vandiver. Her husband, Ernest Vandiver, was governor of our state from 1959 to 1963 and also served as lieutenant governor from 1955 to 1959. She was also the niece of United States Senator Richard Russell. She's been a real fixture in the community in Livonia, and she's very gracious. During her husband's service as governor, she took an active role in mental health issues that affected the adults in our state, and our community will miss her. So I think it'd be appropriate at this time, if you don't mind, to stand and have a moment of prayer in remembrance of Ms. Betty Russell Vandiver.
Let us pray.
Amen. Thank you.
Thank you, Senator. Chair recognizes Senator from the 34th at this time on a moment, or a point of personal privilege.
Thank you, Mr. President, members of the Senate. I rise to offer you all an opportunity to join me in a bipartisan effort on this urgent resolution I've had drafted. It states urging the United States Congress to establish a policy whereby public facilities shall be required to provide adult changing stations and for other purposes. Whereas the Federal American with Disability Act of 1990 and existing federal regulations and standards require that specific building structures and facilities be accessible to and usable by persons with disabilities. And whereas existing law, among others, require that certain public facilities provide seating or accommodations for physically disabled persons in a variety of locations within the facility. And whereas it is not always possible for a disabled person or elderly person in need of diaper change to leave a public facility, and the only recourse for such people and their caregivers is to utilize the floor of the facility's bathroom for such diaper change. And whereas airports across the nation have started assisting travelers by installing adult changing tables for the use of disabled individuals and elderly and their caregivers. And whereas the Georgia State Senate support the accommodation of adult changing stations for disabled and elderly individuals for their caregivers in public facilities as good policies. This is an urgent resolution. I welcome bipartisan support, which I've already started getting some signatures. I will leave it up front, and I ask you to join me. This is a subject that will not go away. I have a constituent in my district who is listening right now live and is urging all of us to join her in an effort to let it be known that these facilities are necessary to make sure that individuals with disabilities continue to have the support of all of us. Thank you, Mr. President. I'll yield the well.
Thank you, Senator. Chair now recognizes our newly elected senator from the 17th. His light is on, wishes to be recognized on the very first day as a senator. He is absent from his seat. We just did seat him as a senator. Chair recognizes Senator from the 41st.
Parliamentary inquiry.
State inquiry.
Would it be appropriate to move to censure for failing to be here on a motion like that, Mr. Chairman?
In many cases, it would. I think we'll give him a pass on this one, but obviously if this trend continues, then we will have to take a little more serious action. Secretary will read a privilege resolution. Did you? No.
Senate Resolution 586 by Senator Hill IV, a resolution recognizing January 22nd, 2018 as Effingham Counting Day at the state capitol, saluting the Effingham County Chamber of Commerce and for other purposes. That concludes the order.
Is there objection to adoption of the resolution? The chair is none. The resolution is adopted. Are there any motions to withdraw or commit? We have a local consent calendar that is before you. Mr. Secretary, are there any objections filed on any of the bills on the local consent calendar?
Mr. President, an objection has been filed on Senate Bill 317 by Senator Williams of the 39th and others.
Senator from the 39th has filed an objection. Will you read? Secretary will read.
Senate Bill 317 by Senator Alvarez the 56th and others, a bill will be titled an act to provide for a homestead exemption from Fulton County School District ad valorem taxes for educational purposes in an amount equal to the amount by which the current year assessed value of a homestead exceeds the just base year assessed value of such homestead, to provide for definitions, to specify the terms and conditions of the exemption and procedures relating thereto, to provide for related matters, to provide for applicability, to provide for a referendum effective dates and automatic repeal, to repeal conflicting laws, and for other purposes. That concludes the order.
Okay, that's the only bill on the local consent calendar, and it is being now contested. And the senators will have 10 minutes at max each side. 39th will be recognized first to articulate. Yes, you are recognized in the well to.
Thank you, Mr. President. I was not sure of what the process was because I've never done this before. But I am objecting to this being on the local consent calendar, being one of the senators representing the affected school district, and having spoken with the superintendent as well as the school board president about the effects of this legislation, and they are still in talks of trying to get the financial numbers and what the actual impact would be. And so they are just asking for additional time to try and figure out what the impact this will be to our local public school system in Fulton County. And as someone who is a firm believer in public education and making sure that I always stand up for students that are in our public school system, I want to make sure that I am looking at every page before I sign on to anything or vote for legislation that would impact our public school system. Thank you.
Thank you, Senator. Now, Chair recognizes Senator from the 35th.
Thank you, Mr. President. I am a signer on this bill. I thought the bill was a good bill for my community, but I've had calls from the community and from some of my constituents who asked me, what effect is this going to have on the system? And I couldn't answer that. And when I called our school superintendent, who is the person that represents South Fulton, then she asked me for a few more days to look at this and asked me to take my name off. I will not take my name off, but I will wait and be able to answer the questions. So at this time, I will honor what the senator from the 39th, who also represents the other portion of South Fulton, is asking for at this time. Thank you. Mr. President, I yield the will.
Thank you, Senator. Chair now recognizes Senator from the 56th.
Thank you, Mr. President. Senate Bill 317 has been worked on since early this summer. As some of you may have seen in the news, Fulton County did the assessment of property taxes which caused great strain to many property owners. In fact, some folks saw increases from 200% to 300% of their home values. This was a large outcry that we all heard from, hosted a committee meeting during the summer, and the output from that was to have a consistency in the way we handle property taxes. So for those that are not completely familiar, your property tax bill has three portions to it typically. It is the county portion, in the case of Fulton, the schools portion, and then a city portion. All this will do is for the schools portion is give the voters of Fulton County Schools, the people that live in that area, the opportunity in November to vote for a limit on how much their property tax can increase, no more than 3% or the rate of CPI. Now, it's important to note that already exists on the county portion of their bill, as well as in one of our cities. So this is just a consistency, as well as make sure that no one ever gets taxed out of their home. We have worked very closely with the school board. Apparently, perhaps they're not talking to each other very well, but there is broad support for this, and most importantly, broad support from those folks who live in their houses who cannot be afford to be taxed out of those houses. And to have the school district live on the rate of inflation increase only is more than reasonable and just. If there are no questions, I will yield the will.
Question? Chair recognizes Senator from the 40th for a question.
Senator, is it not true that when these assessments came out, this was a tremendous burden on a lot of people? Is that not true?
That is true, Senator. Many families were at risk of not being able to pay their taxes and keeping their homes.
Furthermore, is it not true that the reason we are taking this action is because with some of the assessment increases, the Commission of Fulton County refused to lower the millage rate, and that's why we find ourselves in this mess?
That is certainly part of the reason, Senator.
Thank you.
Chair now recognizes Senator from the 41st for a question, if the senator will yield.
Senator, yield.
Yes.
Senator, is it not true that in a case like the 2008 recession, 2009, 10, that if you bought a house in 2010, let's say, you could actually be paying property taxes 30, 40% less than a few years earlier?
Senator, I'm sure in 2010, different people had different valuations of their house. That's correct.
Thank you. And isn't it not true that if recovering from a unique and special circumstance like this, they saw where, you know, the populace did not foresee that the rates would go up more than 3%, but you're kind of recovering lost revenue from before because of the recovery. So couldn't this have the unintended consequence of truly depressing the income of the school system?
No, Senator, I do not, because if you think of a 3% or CPI increase, let's say your property value went up 20, 30, 50, or 100%. Your salary did not. And ultimately, we have to remember that it is the homeowner and the family that has to pay those. And we need to keep them consistent with what their rate of pay is, as opposed to always jumping to the highest dollar value for government.
Thank you, Senator. Further yield. Is it not true the state has stopped paying some health insurance cost of school employees like bus drivers and cafeteria workers? And the state has stopped paying certain funding as far as transportation costs of local school districts? Is that not true?
Senator, well, I appreciate the line of questioning you're going down right now. What I'm focusing on is this bill for Fulton County Schools alone.
Certainly, Senator. But is it not true that the state, you know, once comprised about 60% of our public education cost on a local basis, and now the burden is much more heavily on local school districts? So to protect our schools, to make sure the student-teacher ratio is good and public schools are well funded, we should be very cautious on what we do to tie the hand of local school districts.
Well, Senator, I think ultimately we have to be most cognizant of the people of Georgia, because whether it's a state tax or a local tax, they are the ones that are ultimately paying for that. And, you know, there were many calls from folks to make this a complete freeze. I worked with my colleagues along both in the delegation as well as across the hall in the House, and talking to the school board to come up with a reasonable increase, which was up to that 3%, as opposed to having a total freeze. So it still gives them the ability to grow.
One final question, Senator. Is it not true that if a school system is not at the millage cap, that the lost revenues from the assessment freeze could be made up by a millage increase, and therefore you will raise the same amount of revenue, but it will affect different people. So this may actually cause some people to pay higher taxes and lower taxes if the school district recovers all the lost revenue in a millage increase rather than having the assessments do it.
Senator, I would not agree with your assessment on that, and it is important to note again that all this does is give the people an opportunity to vote on it in November. And I know that there's no one in this body that would want to prevent the people from having an opportunity to express themselves in the ballot box in November. If there are no questions?
No further questions, Senator.
Thank you.
Thank you. The question is on the adoption of the local bill that is on the contested calendar, Senate Bill 317. All of those in favor will vote aye. Those opposed, no. And the Secretary will unlock the machine. I'd like the Senate to join me in welcoming back our newly elected senator. The senator from the 17th has made it back. We appreciate you being here. We missed you during the points of personal privilege. On the passage of the bill, the yeas are 36 and the nays are 17. This bill, AMC Rex Constitutional Majority, is therefore adopted. Chair now recognizes the Majority Leader, the senator from the 46th.
Thank you, Mr. President. I move that House Bill 159 be engrossed.
Senator has moved for engrossment of House Bill 159. Is there objection? There is objection by the Minority Leader. Senator from the 41st, would you like to be recognized? You are recognized this time.
I'll be very brief. We know the issue of engrossment and why I have an objection to it in almost all cases. Just want to briefly say this is a serious case, a serious bill that has been worked on for a number of years. We need to adopt our adoption laws in this state. Many of us feel that by putting House Bill 359 on or other issues that there should be an ability to perfect this bill. And I would hope that you would allow each senator to take the time to amend this bill or attempt to if they should like. Engrossing it prevents that. This is very early in this session. I can understand last week we might not have time to perfect something. At this point, if you want a perfected bill, if you want the most input to make the strongest, best bill for Georgia's children, you will not engross. So I urge you all to vote against engrossment. Thank you.
All those in favor of the motion for engrossment will vote aye. Those opposed, no. Secretary will unlock the machine. On the motion for engrossment, the yeas are 36, the nays are 17, and House Bill 159 has now been engrossed. Secretary will read House Bill 159.
House Bill 159 by Resolution reads of the 34th and notice, a bill be titled, an act to amend Article 1 of Chapter 8 of Title 19 of the OCGA relating to general provisions for adoption so as to substantially revise the general provisions applicable to adoptions, to change the requirements for adopting children, to provide for a non-resident to allow an adoption of his or her child, to provide for adoption of foreign-born children, to provide for a waiver to revoke a surrender of parental rights, to change the age for individuals to access the adoption reunion registry and for other purposes. The Senate Judiciary Committee offers the following substitute to House Bill 159. A bill be titled, an act to amend Title 19 of the OCGA relating to domestic relations so as to substantially revise the general provisions applicable to adoptions, to change the requirements for adopting children, to provide for a non-resident to allow an adoption of his or her child, to provide for adoption of foreign-born children, to provide for a waiver to revoke a surrender of parental rights under certain circumstances, change the age for individuals to access the adoption reunion registry, to revise and provide for forms, to amend Code Section 1511 and 320 of the OCGA relating to termination of parental rights so as to correct a cross-reference, provide for the creation, authorization, procedure, revocation, rescission, and termination of a power of attorney from a parent to an agent for the temporary delegation of certain power and authority for the care and custody of his or her child, and for other purposes. That concludes the order.
Chair recognizes the distinguished Judiciary Chairman, the Senator from the 23rd, to present the bill. Please give the Senator your attention.
Thank you, Mr. President, fellow senators. It is my privilege to bring to you House Bill 159. It has been almost 30 years since Georgia updated its adoption laws. During that time, it has become clear that we need to modernize adoption in Georgia. New issues in family formation and parental responsibility have been identified and need to be addressed. It is important to give parents choices. Barriers to child placement are perhaps a reason Georgia adoptions are below the national average. While Georgia ranks 8th in population among states, we are 19th in the number of adoptions. Nationwide, the average rate for adoptions is 50% higher than in Georgia. The availability of adoptions makes it more likely that pregnant mothers not ready to form a family will choose life over abortion. Similarly, responsible single parents face difficult temporary situations like military deployment that impair their ability to carry out child-rearing duties. They must have a viable way to delegate decision-making authority to protect their children. This bill, as perfected by the legislative process, deals with these issues on a comprehensive basis. It is a clean bill focused solely on protecting child welfare while respecting our state agencies such as DFACS that play such a key role in stepping in when bad choices have been made. We have not tried to address state or private agencies in this bill. There is a need to protect faith-based organizations that play a vital role in this area, and we will address that by separate legislation. This bill combines the basic parts of two bills, HB 159 and HB 359. Both deal with Title 19 of the Georgia Code. The original adoption bill passed the House without a single no vote. HB 59, the Parental Power of Attorney bill, incorporated prior Senate initiatives and priorities and passed both chambers overwhelmingly, but was vetoed. The governor's concerns have been addressed in the combined bill you have before you today. There are many technical aspects of this bill as pertain to the details of the adoption process. We have relied upon input gathered from institutions such as Emory University, courts, legal practitioners, and agencies to strike the right balance for Georgia. A lot of hard work went into perfecting this legislation. I want to thank Representative Burt Reeves for sponsoring the bill. I also want to thank all the senators for providing comments between sessions. The President Pro Tem's office provided much needed technical assistance. Finally, for leadership through the process, I especially want to thank the Lieutenant Governor. I will walk you through the prominent features of the bill. First, the bill clarifies the exclusive jurisdiction over adoption lies in the superior courts. Next, the bill clarifies venue in the case of military adoptions and adoptions under the Interstate Compact. Next, the bill recognizes foreign adoptions or their equivalent. It also, in the case of foreign adoptions, allows our courts to establish the birth date of the child, an important vital statistic where the issue is in doubt. Next, the bill expands who may bring an adoption petition. Previously, for persons between ages 21 and 25, this was limited to married couples. Now, relative adoptions are included, such as in the case of older siblings. The 10-year age differential is likewise removed in the case of relative adoptions. Next, the bill continues to allow regulated placement agencies to assist in birth mother living expenses. We have, though, eliminated a proposal to allow private attorneys to have the same power. This restriction is necessary to avoid increasing the cost of adoption and the risk of unlawful inducements, that is, the danger of creating a market for adopted babies. The bill does add counseling fees and legal fees to medical expenses as things that can be covered for the birth mother in private attorney adoptions. As for living expenses, these can still be paid through agencies, even in cases handled by private attorneys. A right of action is created for persons or agencies injured by a violation of Georgia's anti-inducement law, authorizing recovery of treble damages and attorney fees. Next, the bill limits when a birth mother can waive her 10-day right to rescind an adoption. She must be 21 years old. She cannot waive during the first 72 hours following birth. And her attorney must certify that the waiver is voluntary and knowing. Next, the bill clarifies how biological fathers are dealt with in adoptions. If a legitimation petition is filed, the court can take into account the father's failure to support and can receive evidence of abandonment from the mother in affidavit form or through teleconference remote hearing format. In such proceedings, the court shall be guided by what is in the best interest of the child. The standard of proof is by preponderance of the evidence. Next, the bill expedites the process of locating a missing parent by allowing for publication of notice to proceed simultaneously with efforts to perfect service and without obtaining a court order first. This should help bring the average time for adoption in Georgia down from 30 months to a timeline that's closer to the national average, 13 months. Next, the bill makes it clear that for orphans there is no requirement for appointing a guardian and obviously no surrender of parental rights. Next, the bill for the first time codifies and spells out 14 factors that the court must examine in determining whether adoption is in the best interest of the child. Next, the bill clarifies the conditions under which information about the biological parent can be released and what information can be released. It reduces the age of access to the reunion registry from 21 to 18 and increases the type of information available where biological parents and children are seeking to reunite. About half of the original adoption bill is taken up with revised forms that are needed in different adoptive situations, and I won't go through all of those. Finally, the bill expands parental leave policies for school system employees to give adopted parents the same rights as birth parents. Turning to the parental powers of attorney, the bill expands to whom parents can delegate caregiving authority with respect to children. This authority would typically include decisions such as health care and school enrollment. Current law only allows delegation to grandparents, but that law has worked well. This bill would allow parents to designate other family members to hold a power of attorney similarly. It also allows parents to delegate a power of attorney to a nonprofit or faith-based organization selected or person that's vetted by one of these organizations that are focused on providing child or family services. The authority would not include consents to marriage or adoption, nor would it include consent to abortion or termination of parental rights. Very limited power of attorney. In cases not involving military deployment, the power would be limited except in situations involving grandparent powers to 1 year, but it can be renewed. For grandparents, the power of attorney would be unlimited or indefinite. In cases involving military deployment, it could extend beyond 1 year to the term of deployment plus 30 days. The agent in a power of attorney for child caring responsibilities would be charged with acting in the best interest of the child. There has to be a criminal background check done on the proposed agent. The agent cannot be a sex offender or on the child abuse registry. Where one parent has sole custody, notice must be given to the non-custodial parent within 15 days. The non-custodial parent has 21 days to object to the delegation and in effect stop it from happening. The power cannot be used to interfere with custody orders, visitation, or child support. Nor can the power be used to subvert a defects investigation or where there is an open defects case involving the child, parent, or another child of the parent. Most importantly, the bill cannot limit in any way the power and authority of the Department of Family and Children Services. The bill does allow for caregiving decisions to continue uninterrupted without going through the cumbersome process when parents believe they need temporary assistance of other family members or organizations they trust. The power can be revoked at any time by the individual executing the power of attorney or by any court of competent jurisdiction. Our own senator from the 45th has championed the protection of children and has worked tirelessly to give parents this tool to aid them in carrying out their child-rearing duties. On your desk are letters of strong endorsement. These include one from Andy Stanley, senior pastor with North Point Ministries, also from Andrew Brown with the Foundation for Government Accountability, and from Cheryl Cody of LaGrange, Georgia, whose organization, Twin Cedars Youth and Family Services, is implementing the Safe Families for Children program. This is not a unique bill to Georgia. 14 other states have enacted similar legislation. Included in these are Maine, Mississippi, Arkansas, West Virginia, Kansas. All of these have had good experience with this type of power being given to parents. In fact, in Florida, where legislation like this is enacted, it has become an important tool utilized by their equivalent state agency to our DFACs. We need to give families a tool that does not require government intervention. We need to give DFACs a community resource in aiding them in protecting our children. We need to keep kids out of the foster care system where they're not at the stage where that is necessary. And we need to keep kids from becoming wards of the state. In short, I hope you would join me in advancing the welfare of Georgia's children by voting for HB 159. I will be happy to answer questions. If there are none, Mr. President, I yield the well.
I believe you do have one question. Senator from the 42nd, you wish to be recognized for a question. If the senator will yield.
Yes, thank you, Mr. President. Does the gentleman yield?
Gentleman yields.
Thank you. Wanted to ask about Governor Deal's prior veto of the power of attorney piece. I know you indicated that his concerns had been met in this new piece of legislation.
We have addressed those concerns.
And has he, the last information, if you'll further yield, that I had was that he felt that this was far from a clean bill. So I just wanted to hear your opinion on that.
We believe it is a clean bill. It does not delve into the area of protections for different child placement organizations. That was something that, as I indicated earlier, is being broken out and will be dealt with by separate legislation. It is, his veto message indicated that he wanted to see comprehensive child care legislation. And that's why this broadens the areas of child care that are protected, not just to the adoption area, but also into the voluntary delegation of agency powers. This satisfies one of the issues that was raised in the message. A second issue is that he wanted to make it clear that the authority of DFACs was not in any way undermined. This legislation has provisions that state just that, in addition to the provisions that limit the use of this in the case of DFACs investigations.
Thank you.
No further questions, Senator.
I urge your support for HB 159.
Chair now recognizes Senator from the 14th to speak to the bill.
Thank you, Mr. President. I have to be honest, in the very beginning, I was pretty concerned about this bill. You heard a lot of things about what it was going to do and what it was not going to do. But I was pleasantly surprised when I had the opportunity to really start looking at what the bill said. You hear a lot of things out there about what the bill might do, might not do. But after being assured by the author and a senator from District 23 that it will no way affect the current status, the current legislation we have. Many of you know how adoption is very personal to me. So if I can take this just for a second and bring this home to share with you two pieces of this bill that are very important. First of all, many of you know, you've seen our sweet daughter, Faith, who's been here many times. 17 years ago, when we were looking to adopt, we were able to bring a girl out of a crisis pregnancy center into our home. We brought her down from Tennessee. So we were doing a private adoption. We brought her into our home. The father of Faith was from Pakistan. He had come over here and then he had left about the 5th month of Elisa's pregnancy. As we started going through this process, trying to assure Elise that we wanted to love on her as much as this baby, we found out how difficult it was to terminate the rights of a man that had abandoned this girl, this young girl, 22 years old, and fled back to Pakistan. He had abandoned her. And yet, here she was in our home, wanting to give this child up for adoption. And there was a doubt in her mind whether it could happen because we couldn't locate this individual. Clear abandonment. This bill addresses that. The second one was this. The day that Faith was born, August 16th, 2000, that sweet little baby was brought out, put in the arms of my wife and I, and after a period of time, we were able to bring her home. The challenge we had was you have a 10-day period. Elise wanted to terminate her rights at that point, but she couldn't. Clearly, she did not want to come home with us again, although we had loved on her. She felt like that was her home. She did not want to come home and be faced with the emotional challenge of having this baby and watching this baby as she's in the home. She wanted to move on with her life, but yet she couldn't make that decision. So we had to place her in a hotel. For 10 days, she had to sit there in a hotel and think about, how do I move on? And I've been assured, and if you look at this bill, it addresses that. Ladies and gentlemen, I realize it's not perfect, but I would submit to you, rarely, if any time, do we ever pass a perfect piece of legislation here. We pass legislation that we believe in our hearts is good legislation that moves us forward. Do we have to go back to it at times and change it or to make it stronger or better? Sure. And that's what you heard from the senator from the 23rd, that there's another piece of legislation coming to address issues that are dear to all of us concerning faith adoptions and others. But I encourage you to support this bill. It's good, it's personal, and I applaud you for working on it. With that, Mr. President, I'll yield the well.
Chair recognizes Senator from the 22nd. 22nd.
Thank you, Mr. President. I'll be brief in talking about just a couple aspects of the bill that gives just some concern. And it is interesting to note that the senator from 23rd stated that on the issue of faith-based legislation will be addressed in separate legislation. And that is absolutely fine, and those are issues that can be taken up. But it also is interesting that the issue of HB 359, or dealing with the power of attorney, we believe should also be taken up in separate legislation, because it has a couple of issues that can actually be good but still need to be fought over or discussed in a different form being attached to this particular bill. Specifically, I'm looking at two areas that give some concern over this particular bill. It's on page 102, which is line 3513, which was mentioned, and it was talked about the fact that a potential person who has power of attorney cannot be on a sex registry. And obviously that is very good. But whenever we start talking about dealing with the best interests of children, when we're dealing with the domestic court, there are so many other issues that still come up other than just the fact that the person is not on the sex registry. Whether the person has a criminal background check, certainly that would be a good feature, but a judge is going to look at all sorts of different things even in that criminal background check. Are there theft charges? Are there fraud charges? Is there a simple battery charge? Even just a charge, not even necessarily a conviction. Those are things that a layperson may look at and say, well, that doesn't matter, and cannot necessarily format it and put it all together and understand why, if a person has those particular just charges, not even convictions, but just charges, how that can impact on being able to care for a child, even if it is just for a period of 1 year. So certainly the part about sex registry is great. Certainly the part about giving a criminal background check is great. But certainly, a lay person, a young lady, or even two parents who are sitting there looking at that may not be able to put those two things in perspective and realize that even a charge for certain things basically shows that this person may not be in the best interest of the child. And that's something that judges would normally look at. And even if a potential parent, was to protest and say, well, judge, that's just a charge for theft. That's just a charge for fraud. That judge many times would rule that that person is ineligible to have parental custody of that child because of those particular charges after they got into the facts and circumstances of the case. That is a very serious concern, especially depending on the circumstances that the young lady or the parents are actually putting the child up for this power of attorney. A second one actually deals with page 103, which is line 3548, which becomes even more problematic, which says the individual should not execute a power of attorney under this article for the purpose of subverting an investigation of the child's welfare. Now that seems pretty obvious. Certainly DFACS has gotten involved. If you do the power of attorney, certainly you can look at that and trace that and say the reason why you did the power of attorney because DFACS was involved. But how about those situations where other family members come into a household and even if they're not making a threat of calling DFACS, are concerned about certain things? So even though you can't trace that the power of attorney was used for the purpose of subverting DFACS or purpose of subverting the child investigation, in reality, that's exactly why it was used. Because other family members or other persons was looking at the situation in the household, and the person who gave the power of attorney realized that even though we have not gotten to the point of actually a formal investigation, this is something that is actually possibly going to happen, and then they go ahead and institute the power of attorney. Those are just two aspects of that bill that's been added on to this adoption bill that are very troubling. Doesn't mean that anybody's a bad person for wanting to put them on there. It just states that why not deal with those two issues in a more formalized way instead of putting it into this whole big adoption bill. Same way we're going to do with the faith-based initiative. Have those conversations in a separate form. And that's one reason why I voted against engrossment, to have these kind of talks, to have this conversation. And so let's do them separately. But those are two issues. Those are two serious issues that do exist in that particular area. I'll yield the well, Mr. President, unless there's any questions.
Senator from the 36, your light is on. Is it in purpose for a question? You are recognized this time for a question.
Thank you. Does the senator yield?
Yes.
I had a question going further on this power of attorney. What you know the bill thoroughly because you all have been working on it in judiciary, and you are a learned attorney. But in terms of this added language, if a parent wants to revoke power of attorney, how would they go about getting their child back?
Well, I believe the bill does address that. It says that they can do it through written revocation. Now, of course, it doesn't directly state.
Say that again. Written what?
Written revocation. They can do a written revocation, and it may actually be insinuated that you could do it orally, quite frankly. So I think that the ability to revoke may be there, but the question is, it's a two-form question. Number one, is it only through written revocation, which is specifically stated. There's no doubt that part is in there. It may be implied that oral could also do it. But the question then becomes, even if you do a written revocation, what has changed in that relationship to where the person who has the power of attorney can still say, well, I believe that me having the power of attorney is actually in the best interest of the child. It does create an issue there. The greater issue is not only about revocation, but the greater issue is not only the two that I pointed out, but to understand the steps that the courts normally go through when talking about best interests of the children. We're talking about parents that come in there, two parents who come into domestic court, and judges have very difficult time between two biological parents determining who is the best interest of the child. Here we have just a layperson, and that's what they are, a layperson now determining that I'm going to give a power of attorney over and really make a judicial decision that judges languish over and that no parties ever come out of that courtroom actually feeling good about. That becomes the problem in this particular situation.
Well, if a parent, further question, if you will accept it, if the parent wanted to revoke the power of attorney, but the parent with possession, the non-parent, refuses to return the child or sends the child to another state, what occurs at that point?
And I think
that seems to be something that's not that atypical, not that hard to understand happening. Wouldn't that be a burden on state and local law enforcement?
And I think what the gentlelady is saying is basically, does this open up some issues that would not normally exist? And the answer to that would be absolutely. It does open up issues that normally would exist. Now you have competition between the biological parent or the parent who's now given over the power of attorney, and does it open up some issues that normally would not be there? And the answer is absolutely yes.
One final question, if you are able to do so. I know that the version that was passed and put on the governor's desk was vetoed, that addressed this non-judicial turning over of children. Have you read the governor's veto message on that? Do you? I'm not asking you to speak for the governor, but the governor vetoed this, and now it's been put in another bill. What was the reason for the veto?
I think there's various reasons. One was concerned about the child welfare aspect of it and usurping the ability of DFACS. The language itself covers that. The plain language appears to cover that, but the reality does not cover that. The reality is that when you talk about child investigative services and bringing those into persons' lives, it's not as simple as just, I'm going to go call child investigative services. You know I'm about to go call them, and then somebody executes a power of attorney. What actually happens in many of those situations is families are languishing and going back and forth over this. And so what you're going to find is that the parents will realize that child investigative services may not be called now, but that call is eventually going to be coming. And so the paper trail that I think we're thinking is so simple that we can say, oh, there's no doubt. Here was the investigation. You executed the power of attorney. There's no doubt that we can link the two. I don't think it's going to be quite as simple as what we're looking at.
Thank you.
Thank you. I'll yield the will, Mr. President.
The senator has yielded. Senator has yielded. Chair recognizes Senator from the 3rd.
Thank you, Mr. President. Last year, working with the chairman of the Judiciary Committee, I authored an amendment to this bill to ensure that faith-based child placement agencies in Georgia would never have to choose between closing their doors or violating their faith. Because you see, faith-based organizations have provided an important service to children in need for centuries. These organizations provided child care and child placement services for centuries, even before states became involved in this process. So it had not gone unnoticed to many people in our state and to these agencies that across this nation, states are actually failing faith-based child placement agencies, and they're doing so in two ways. Some states have actually, through legislation or policies, forced these agencies to choose between violating their faith or closing their doors. States have also failed these agencies by failing to give them legal certainty so that they don't have to worry or work in fear of lawsuits that could force them to close their doors. There are many people across this state in Georgia who do not want to fail the agencies in our state. We want to do what we can to ensure that they continue to serve the children and the people of Georgia. Well, as the amendment progressed along with the bill, two things became apparent. First, that we needed to further refine the language of that amendment that offers protections to our faith-based agencies, and that work will be completed in the coming days. But it also became apparent that these important protections for faith-based agencies were being unfairly attacked as a cause of delay for the passage of the adoption bill, when the truth was that the bill itself needed further work and refinement. And the Senate took it very seriously. And we've worked very hard over the past year to perfect this bill. And our work is now complete. And so by moving the protection for faith-based agencies to a standalone bill, we have removed these distractions from both the adoption bill and from the part of that bill that offered protections to our faith-based agencies. And so in the coming weeks, our attention will be brought to this standalone bill, which will ensure that our agencies in Georgia do not have to make that choice, which could mean that they would go out of business. And we will see, the people of this state will see exactly where their government stands on this issue. Thank you, Mr. President. I yield the will.
The senator has yielded. You'll have another chance. Chair recognizes senator from the 48th. 48th.
Mr. President, ladies and gentlemen of the Senate, first let me apologize. I've been ill over the weekend. I have fully recovered, but my voice is a little gravelly. I also came here not prepared to speak to this bill. I thought it was coming up on the calendar tomorrow and was surprised to learn that we were voting on it today. But as someone who was adopted as an infant and who is a strong supporter of adoption, I felt compelled to address the bill, to rise in support of the committee substitute that was voted out of the Senate Committee on the Judiciary. Over the holidays, my mother was doing some house cleaning, and she found in the attic our old slide projector and 2 boxes of photographic slides that were taken when my sister and I were children. And so for one night over the holidays this weekend, 3 generations of the Schaefer family assembled in my mother's living room and watched slides from when we were children. There were pictures of me as a baby, pictures of me taking a bath, pictures of me playing in the sandbox, pictures of me at Disneyland. And then there was a picture that was thrown up on the wall of my mom and dad, young, dressed for church, with 2 children dressed for church that I originally thought were my sister and me. They were about 1.5 years apart. But when I looked closer at the picture, I realized it was not my sister and me, it was these 2 girls that I had never seen before. I felt like I was in an episode of the Twilight Zone, seeing a family picture of my youth, and neither my sister nor I were in it. Well, my sister and I both sort of asked at the same time, who are these 2 girls? And my mom said that about 1 year before I was born, she and my dad had tried to adopt these 2 girls, 1.5 years and 3 years old, named Tammy and Angel, and that the adoption had fallen through. And afterwards, I asked my mom more about it. She said that their birth mother had changed her mind about giving up the children for adoption, and they were returned to her, and she had not seen them or heard from them again. And I asked my mom, I said, well, do you ever think about them? And she says, I think about them every day. The 79-year-old woman, for the last 52 years, has thought about these 2 little girls every single day of her life. Little girls that spent only a few months with her and my dad 1.5 years before I was born. I believe that the committee substitute that's before us will simplify and give certainty to the process of adoption, and that is a worthy goal that deserves the support of this body, and that's why I rise in support of it. Now, the original House bill had some problematic provisions that I don't believe simplified the process of adoption. In fact, I believe that they complicated the process of adoption, made it more burdensome for adoptive families, and added to the cost of adoptions. We've got a law in Georgia that prohibits the payment of money to induce a mother to give up her child for adoption. And the House bill, as it came over to us, effectively repealed that prohibition. It actually left it intact. The code still says in one place you can't pay money to induce a woman to give up the adoption, and then it created an exception that said that doesn't count any money that you pay to the woman to induce her to give up the baby for adoption. I think that if you think about this provision for more than a few seconds, you will realize that by creating the expectation that there should be a payment for every child, that it will drive up the cost of adoption for everyone. That's not in the best interest of children. It's not in the best interest of adoptive parents or adoptive families. There's also a provision that lowered the age for single men and women to adopt children, dropped it to 21 years so that a unmarried 21-year-old man or woman could adopt an unrelated child. No one's been able to explain the purpose of this provision. Somebody said, well, maybe an older sibling might need to adopt a younger sibling, if the parents passed away. But that's not what the provision said. You could accomplish that by simply saying that the minimum ages don't apply to siblings adopting younger siblings. The provision allowed 21-year-old unmarried men and women to adopt children, to actually pay for the adoption of children that are not related to them. These provisions, thanks to the diligent work of the Senate Judiciary Committee, have been removed from the bill. I think that the bill before us makes needed improvements to the procedures for adoptions and will prevent them from increasing in cost, and I rise to support it. I do support the legislation that the senator from the 3rd District mentioned, providing protections for faith-based adoptions. I also agree that that doesn't need to be in a bill that simply provides the changes to the procedures, just like they should never have inserted these other provisions, these more offensive provisions, in a bill that was advertised to improve the procedures. So I intend to vote yes on the legislation and urge you to do so as well, and if there are no questions, I yield the well.
No questions, Senator. Chair recognizes Senator from the 42nd. 42nd.
Thank you, Mr. President, and good afternoon, colleagues. I am very glad this afternoon to see HB 159 on the floor. We do have a desperate need to update our adoption laws. They haven't been updated in more than 30 years, and in that 30 years, a lot has changed in the procedures surrounding adoption, and our policies have simply not kept up. Because of that, adoptions take much longer in Georgia than in other states. For example, here in Georgia, adoption of kids who are in foster care takes over 30 months, whereas it takes an average of just over 13 months nationally. Likewise, our adoption laws have no process to account for international adoptions, which have become so common over the intervening decades. Right now, we see a trend of Georgians going to other states to adopt because of the failure of our policies and procedures to keep up. We, of course, want Georgians to take advantage of the wonder of expanding their families and helping kids here in Georgia. So the purpose of HB 159 is to bring our laws in line with the national trends and to make adoptions more efficient and inviting right here in Georgia. So the bill is an unequivocal good thing. What's concerning me is the addition of SB 359, a bill that Governor Deal vetoed. Last year, language added by this body killed the bill at the end of the session, forcing these families that we've been discussing to wait a whole extra year on an already long overdue adoption code update. I do fear that attaching an unrelated and controversial measure to this bill could have yield the same outcome, which would be so unfair to the families and kids in our adoption and foster care systems. There hasn't been, that I have heard, an indication that Governor Deal or DFACS feel differently about the child custody power of attorney measure than they did last year. Governor Deal vetoed SB 359 because it simply created legal opportunities for people who were child abusers to become surrogate parents. There's no true oversight written into it. Let's not forget that, very unfortunately, the vast majority of kids who are abused by someone they know. So it's not rare, as we know, for people with bad intentions to try to get close to a family that might be in distress to volunteer with kids. We see that time and time again. So sometimes the person that seems like they would be the obvious answer may not be. And with no oversight, with no real check, that couldn't be discovered. Even if there were a check, it didn't seem to me that in this legislation that it would be disqualifying, for example, if you had already had your kids removed from your custody. There was a case that I read about where a woman who had adopted a child, this was in, I believe in Wisconsin or Michigan, she had adopted a child. She wanted to rehome that child, as it's called, so she signed a power of attorney over to a family that she found online. She tried to check on this child, couldn't find her ever again, ended up calling the police, and it turned out that this couple frequently rehomed kids and that they had, in fact, had their own biological children removed from their care, years prior. Simply put, they were absolutely not appropriate people to be caring for a child, and without a check, you just would not be able to find that out. There's just no real meaningful assurance of child safety, which then, of course, creates legal uncertainty for all involved, and it can therefore promote placement instability, impose no obligation to provide services to a desperate parent who's looking for help, and doesn't place the best interests of the child or the child's developmental need to be with a familial or familiar caregiver at the front. If the power of attorney idea is a good one, and certainly it may work very well in many instances, although I think I've enumerated a few instances that could cause us to try to say, how could some of those holes that are glaring be plugged? That would be, of course, my preference. But if it is a good idea, let's let it stand on its own. Let's debate it on its own. Let's pass it on its own. Let's perfect it. But let's not risk the adoption bill for the second year in a row. The adoption bill has probably had more work gone into it than the vast majority of other bills that pass out of these chambers. By attaching an unrelated and controversial measure that the governor has expressed and continues to express his opposition to, we are playing games with an adoption bill and risking it, and I don't think that's the most prudent course of action to take for families in Georgia. Mr. President, if there are no questions, I'll yield the well.
There are no questions, Senator.
Thank you.
Chair recognizes Senator from the 18th.
Mr. President, thank you. Colleagues, I rise to really address just a few provisions of the bill, and specifically what we've called is HB 359. And I want to begin my remarks by thanking the chair of the Judiciary Committee. Only those that have worked on that committee and the others that attended the meetings know the untold hours that our Judiciary Chairman put into this bill to make sure that we had the best bill that we could bring to you in a timely manner, and I want to thank the Chairman along with everyone else who worked on this. So the question really is, what does this provision do? What does HB 359 do? Well, it ensures that parents who make decisions about their children can delegate that decision-making authority to someone else that they trust to care for their child for a short period of time. That's the issue. And that is the crux, and that is the thrust of what 359 does. So the question in legal terms, of course, would be, is this right that we have as a parent to care for our child? It's a right, but it's also a responsibility, isn't it? Do we then have that right to transfer that to someone for a short period of time? I would suggest to you that we do, that parents do have that, and they ought to have the right to transfer that for a short period of time. I think it's beyond question. We all have the right to take care of our children, right? We all have that responsibility. It's not just a right, it's a responsibility. So the question is, what would be the reason we couldn't delegate for a short period of time? And the truth is, there's really not a good reason. Because if, in fact, you as a parent, I as a parent, citizens of this state as a parent, have, by virtue of some miraculous thing that happens biologically when we touch our child, or you just happen to have really good God-given walking around sense, you have enough sense to know how your parent, your child ought to be cared for and how you should work and serve as a parent. If you have that, you also have enough sense to know who to entrust that precious gift to in the event that you need to transfer this right and responsibility to someone else, again, for a short period of time. Don't we want to really encourage continuous, significant parental involvement in our child's lives? Well, of course the answer is yes. But let me ask you to think a little bit beyond what immediately comes to mind. Not our normal day-to-day where things work out the way they're supposed to and life is humming along the way you want it to. What about when you have something thrown at you either involuntarily because of a drug issue or something that you have less control over but maybe more control over in some ways, where you've been called up to active duty, military service, for a period of 6 months? Shouldn't, if we're going to turn to someone to help make the decision and determine ultimately who gets the right to decide what happens to your child while you're serving our country for 6 months, shouldn't you be the one that makes that determination? Why would we take that right away? If, in fact, there's a problem, and this is sort of part of the argument the opposition is making to this, and I respect the arguments that are being made, but the real issue is, if, in fact, there is a problem with the agent whom you nominate, who you decide is going to care for your child for this short period of time, the same provisions and protections that our state laws provide that child in the event that you or I or anyone out there get out of line and don't do what's in the best interest of the child, those same protections apply to protect the child when they're in the temporary custody of the person you've nominated and decided to take care of your child for a little while. So the protections are there. So don't be lulled into some sense that this is a wholesale transfer of authority regarding your child to someone and there is no state oversight. All of the protections and provisions of state oversight continue to exist. So do we really want the state to intervene in advance? No, of course not. Let's encourage the use of formal powers of attorney of what is embodied in 359 rather than an informal process that has no oversight. What do I mean by that? I mean give parents an option to have a formal document so that their agent can make important decisions and interact with the school system, with the medical personnel, and do so formally rather than trying to do it informally where there is no oversight. And the real question is this, and this has not been asked in this way, but I ask you to look at it this way. What is the profile of a person who's going to utilize this power of attorney? Think about it. Who is it? Who is the father or mother that's going to go to the trouble to utilize our laws, to get this power of attorney document, to understand it, to nominate someone to care for their child for a defined period of time, to go to all of that trouble? Who's going to do that? It's a thoughtful, caring, concerned, loving parent. And if you're a thoughtful, loving, caring, concerned parent, don't you probably have, and isn't that the profile of the very person and the kind of parent we want to have the ability to determine who's going to care for their child for a short period of time? To those that would misunderstand this impact on faith-based organizations, I would tell you, please understand that this provision, specifically the provisions of 359, protect and empower the ability to protect your children, to protect families, and empowers faith-based organizations in a way that are not allowed now. This is an important, not a landscape shift, but it is absolutely important and an important provision where we're allowing something to happen that we need to do. Friends, as most things in the decisions we make come down to a balancing test. And the balancing test you've got to decide now is who has the right to decide who cares for your child for a short period of time in the event that you can't. Give parents an efficient and thoughtful way to address this issue. 359 does just that. I appreciate your attention, and I hope that you'll join me in voting for HB 159. Thank you.
Thank you, Senator. Chair recognizes Senator from the 29th.
Thank you, Mr. President. Several of the other members have eloquently discussed the provisions of the bill that I think have been added in committee and explained. I wanted to take just a few moments to talk about the procedural history with this legislation and underline some comments the senator from the 3rd made regarding protections of faith-based adoption services. There's been a lot of conversation about the Senate's treatment of this legislation, and I think it's just important to remember, because it's been a few months since we've all gathered back here together, this bill was brought before the full body on the final day of the legislative session, somewhere around midnight. This bill's 100 pages long. You think about the discussion we've had today. I think we've been discussing this bill for an hour and a half or 2 hours, had a pretty reasonable debate. I think members can come away from this debate understanding what it is we're voting on. We weren't really in a position to do that on the 40th day of the legislative session. So I want to thank the chairman of our Senate Judiciary Committee, the working group, for all of the time spent in a deliberative fashion bringing us the bill that we're voting on today, which I will be glad to vote for. The senator from the 3rd made these points, and I'm not going to belabor them, but I do think it bears underlining. When we're talking about the state's policy with regard to adoption, I would think most of us would agree that the underlying policy should be to maximize the number of children who are placed in safe and loving homes. And it's hard for me to square that policy with a failure to protect faith-based adoption services. If we don't protect faith-based adoption services, we know what will happen. This is not a thought experiment. This is not a hypothetical circumstance. From Boston to San Francisco to Washington, D.C. to the state of Illinois, we have seen faith-based providers who have been adopting children into loving homes for decades close their doors because they were forced by the state to choose between their sincerely held religious belief and some new state guideline or state rule. We have a history in our country of protecting the right of free exercise and protecting religious freedom, whether it was the Pilgrims that settled in Massachusetts, whether it was the Quakers in Pennsylvania, whether it was free thinkers in Rhode Island or Catholics in Maryland. We have had a significant history over the last 200 years of protecting religious freedom. And so I agree with the senator from the 3rd. that while that is a very important issue, we should not stand in the way of modernizing our adoption code, because we do agree with this policy of making sure that children are adopted in a more streamlined fashion, that we are closer to that national average that was referred to in the debate earlier. But I think we should be very alarmed about some of the comments that have been made to suggest that because people have a certain religious faith, because they believe certain things, that it is okay for the government to punish those people. That is incredibly alarming, and it is at odds with not only the founding of our country, but with most of the history of our country in terms of protecting religious freedom. And I'll just close by saying this: religious liberty is more than simply the freedom to worship. It includes an ability to make our contribution to the common good of all Georgians without having to compromise one's faith tradition. And without religious liberty being properly understood, all of us suffer, including the neediest children seeking adoptive and foster families, as well as birth parents who wish to turn to faith-based providers in order to place their children with adoptive parents. And I look forward to working with the senator from the 3rd and the distinguished Judiciary Chairman, the senator from the 23rd, so that we can address that important issue. But I look forward to voting for this important bill today and moving that on through the process. Thank you, Mr. President. I yield the well.
Thank you, Senator. To close the debate, Chair recognizes Senator from the 46th.
Thank you, Mr. President, ladies and gentlemen of the Senate. Great day for us to be here today. I'm very proud of this body, the work that we put into this legislation, and the final product. Because you've heard a lot of talk over the last few weeks that the House wants a clean bill to come back to them. I think essentially by that they want a bill with no changes from the House version, and we all know that's not how our system works. We're a bicameral legislature for a reason. It's very often that the House improves on legislation that we pass from the Senate, and likewise we help them out from time to time, and we simply didn't have enough time last year when we got this bill over on the 28th day to thoroughly vet it. And I join in the many commendations of the senator from the 23rd, the hard work he put in during the off season through subcommittee of the Judiciary Committee and private conversations with many interested parties, and all the other senators that contributed to him by giving their thoughts. I especially commend the senator from the 3rd, who with his statesmanship has realized that one of the impediments that the House claimed was not clean or dirty in some way was this provision looking after faith-based organizations. And rather than risk derailing this entire bill, which is a wonderful bill for the children of Georgia and for parents in Georgia, he's agreed to handle that issue separately as a standalone bill, and not in any way giving up on his strong convictions and those of many in this body to protect those rights and encourage religious freedom in this state, but to focus this bill on the children. And there's no way around the fact that this is a pro-life bill. And I wonder sometime, is that part of the opposition that we're getting here from the minority party? This bill encourages young women to give birth to their child, to not choose to abort that child, but to give birth because it creates more opportunities for that child where that mother knows there can be a good, loving family to raise that child. There are more people in this body than I realized before this debate began that either are adopted themselves, have adopted children themselves, have siblings that are adopted. It is very prevalent in our state, and it is great for the child themselves. It is also good for the parent, for the mother to have these options, to know in her heart that that child can be well taken care of and there will be adoptive parents available to raise a child in the event the mom's unable to, or not prepared to, or for whatever reason is not willing to give birth to a child without this assurance that there's a good home for that child. It also is good for parents that choose to keep their child. I think all of us believe in personal responsibility and parents raising their own children and having that authority over their child to raise the child as they see fit. And as the senator from the 18th has just so eloquently pointed out, the power of attorney provision that's in the House Bill 359 section of this addresses that by giving options to that parent. They can keep their child, raise their child to the best of their ability, but if they hit those rough spots in life where they know in their heart they're not capable of providing the home and the wherewithal for that child that they feel like is best for a temporary period of time, no longer than a year, that they can choose, not the government telling them that their child is going into the DFAC system or foster care system, but that they can pick a trusted person, somebody other than just the grandparent, which the senator from the 45th worked so hard on a few years ago, expanding and allowing parents of children to let their parents, the grandparents of the child, raise them or make some of these key decisions for limited periods of time. And mainly we're talking about education and health care, those really important decisions. This bill just expands that list of people approved that you can give power of attorney to for a limited period of time, and doesn't require advance interference by the government to tell you who can raise your child. And there are a lot of different circumstances that can come up. The ones that we always mention here are military service. If you get stationed overseas for 6 months or a year, do you have to let that child go into the foster care system till you come back? That's ridiculous, you know. And it's not just that, though. It can be a drug or an alcohol addiction where that parent of the child decides, I want to get inpatient treatment, and I'm not going to be able to take care of this child for the time that I'm getting healthy. And it doesn't have to be an addiction problem. You could be in an automobile accident and could be seriously disabled for a period of time and unable to care for your own child. It could be financial difficulties. You lose your job. You get foreclosed on. You can't provide the home you know you want your child to have. It can be things even simpler than that. Perhaps your job, you get transferred. You want your kid to finish that school year in the school system they're in. Well, that's easy sometimes when there's two parents. One stays with the children. Heck, it happens in the coaching profession all the time. You know, get them through the school year, then move. But that's not so easy for a single parent. I think that it is just a conundrum that some of the same people that fight so hard on the pro-choice side for a woman to have the right to terminate a pregnancy aren't fighting equally hard for a parent that decides to give birth to make these kind of choices over what's best for their own child. This bill deals with a lot of issues, but at the bottom of the bill, we are looking after the children of Georgia. There are now 14,000 children in this state in our foster care system, and that's almost doubled since 2010. We should be looking for ways to place children with families that will either adopt them or use this power of attorney on a short-term basis instead of pouring more children into the foster care system. This bill does it. And it does it in a way that we avoid some of the known pitfalls. Two of them that come to mind. One is this whole concept of paying people for children. Paying a woman to provide you a child to adopt. And that's really what we're talking about when we deal with these living expenses. Right now, only a registered child adoption agency may do that. Anybody can pay medical expenses or birthing expenses, hospital bills to have a child. That's reasonable. Nobody could say that's an inducement to give up a child. But only these licensed child adoption agencies may pay living expenses. And only after filing a financial disclosure with the judge that approves the adoption, and he reviews those to check off that they are reasonable, that they're not an excessive inducement or payment for the child. The senator from the 49th made a great point on that, that it makes it easier to adopt children if you don't raise that price. And you don't want to put these young mothers in a position where they're deciding where the child will be placed based upon what amount of living expenses can be paid on their behalf. A child adoption agency has to file annual reports that are audited by the state to make sure that they are not giving unfair inducements. We've made this a crime, but we take it so seriously that we have a code section 19824 that makes it a felony offense. Can be fined up to $10,000 in prison for up to 10 years if you give an inducement for the placement of a child. And that essentially includes anything other than the medical expenses related to the pregnancy or the hospitalization and childbirth, and limited living expenses if given by one of these highly regulated adoption agencies. That makes sense to me, and it doesn't seem in any way that the House version would increase the possibility of additional adoptions. The other thing that we haven't mentioned on much is the right of the mother to change her mind. The current Georgia law gives a birth mother a 10-day period to change her mind and decide that she would rather raise that child herself. That makes a lot of sense to me, because I've been there when you have that newborn child in your arms for the first time, and you maybe never knew what maternal instinct was, or you didn't know what paternal instinct was. But once you have that connection with your blood child, you know what I'm talking about. And there's nothing stronger than the love of a parent for a child. It seems to me we should encourage a natural parent to keep and raise their child wherever possible, and to never take that child away from the parent unless they're 100% sure that's the choice that they'd like to make. This bill makes a significant accommodation to the current law, and it allows that 10-day period to be lessened to 72 hours if the mom is 21 years old and waives her right to revoke up to 10 days. That seems to me to be a reasonable compromise. And I have a difference of opinion on this issue with several people, including my wife. And the senator from the 14th, who is an adoptive parent, you can imagine the emotional agony that you would put adoptive parents through if the birth mother changes her mind and takes that child away. And I know that is a terrible thing. This compromise seems to lessen that. So there's no longer, doesn't have to be a 10-day period where they're living on pins and needles. Is that mama going to change her mind? And it knocks it down to 72 hours if they're willing to waive that. I encourage all of you to vote for this. This should not be a partisan issue in any way. It's the right thing to do for the children of Georgia and for the parents of Georgia. And I think it's something that we as a body should be very proud that we took our time and perfected this bill. And Mr. President, if there are no questions, I will yield the well and urge swift passage of this bill.
One question, Senator. Chair recognizes Senator from the 45th for a question.
Would the majority leader yield?
I yield.
Thank you very much, and I appreciate your eloquence in stating, because I am one of those mothers where a birth mother handed me two, not one, but I had the pleasure of having two children handed to me, and that 10-day provision is excruciating for the receiving mother. I have a couple of questions, because there's been so much swirled around here about different bills, House bills, Senate bills, but wouldn't you say that this goes all the way back to 2008, and that's probably why so many people are misspeaking about the bill numbers, the bill names, because it goes back to Senate Bill 88, which was the Senate's conception of the original power of attorney, where grandparents lobbied us in the halls by the thousands of grandparents raising grandchildren. Wouldn't you say that?
Absolutely, and that you predated me with that, Senator. I remember your Senate Bill 3, I believe it was, from a couple of sessions ago that many of us voted for.
Yes, sir. Would you further yield?
I yield.
In 2015 and 2016, Senate Bill 3, wasn't that a number one priority of the majority caucus in the Senate?
Absolutely.
And would you further yield?
I yield.
Wasn't that vote count 43 to 10 that it overwhelmingly passed?
That sounds right. I remember it having very strong bipartisan support.
And so in the evolution of the bill, and I know this bill came through, the power of attorney came through the Health and Human Services. Do you recall in that committee where some members of the minority party that are now speaking against it actually voted in favor of this bill in the committee process?
I remember many said that in our culture today, there are a lot of circumstances where grandparents are already raising their grandchildren, and this simply eliminated some of the legal red tape to do what is, in many instances, in the best interest of the child already.
Would you further yield?
I yield.
Maybe this could refresh your memory, but in 2017, the House vote was 124 to 39, and the Senate vote was 40 to 11. So when you say that that's pretty much an overwhelming consensus, and that was on House Bill 359 that originated as Senate Bill 3 the year before. So a lot of people have gotten up there and talked about, we hadn't talked about this, you know, we did it on the last day. You know, the evolution of this bill, wouldn't you say, has been over consecutive years?
Absolutely, and you just pointed out very eloquently that the House supports that. They can't complain of us connecting the two bills because it's something that the House passed last year, and as well as the Senate, and even in the governor's veto message on 359, he stated, I think he ended that by saying that he believes a comprehensive foster care adoption reform legislative package is in Georgia's best interest in 2018. I think this bill is that comprehensive bill, and I certainly hope it meets with his approval and the House will accept it as is.
And just a couple of more questions,
okay,
if you would further yield. Isn't it true during this evolution that not only Bethany Christian, one of the largest churches in the state of Georgia, North Point with Andy Stanley, I know the chairman brought these up, Perimeter Church is also one of the largest churches in the state of Georgia that has tentacles that go very deep. That through this evolution, through this process, Families First, another big, large organization, that they actually came to the Capitol and testified and have written these letters previously. And that's why it wasn't so hard for us to generate them today. Because all we had to do is say, remember when you wrote that? And they said, yes. Is that not true?
That is true. We all have on our desk this morning a letter from Reverend Andy Stanley strongly encouraging us to pass this bill. And I think the faith community is going to be ecstatic that we pass it and welcome it with open arms.
And wouldn't you also say that it's true that these are the same groups that have worked so diligently, so ferociously on child sex trafficking and have moved the dial on the issue? And if it had not been for them, that we would never be where we are with child sex trafficking. Is that not true?
Very true.
And these are the same children that are caught up in the foster care system and the adoption system. Is that not true?
That's right.
And just one last question. There's been some issues brought up about the instances of when you use power of attorney. And I think there was a reference to 14,000 kids that are in the current foster care system, that it has tripled, not doubled, tripled. But isn't that true? Not because of the antiquated foster care system, of the adoption system like I used 30 years ago when I adopted my kids, but the real answer sir, is they're in the foster care system. Wouldn't you believe, because of the opioid epidemic and the changes in society with substance abuse, wouldn't you agree with that?
And I know that is a major driver of this problem.
No further questions, Senator.
Thank you. I yield the will.
The question is on the adoption of the committee substitute. Is there objection? Without objection, committee substitute is adopted. Now, does any other senator wish to speak for or against the bill? Is there objection? Agreed. The Porter Committee which fail pass the bill. Chair is none. Porter Committee is agreed to. Shall the main question be now put? Are the objections? Chair is none. Main question is ordered. Shall this bill now pass? Question on the passage of the bill. All of those in favor of the bill will vote aye. Those opposed, no. And the secretary will unlock the machine. Senator from the 4th, you have a, no, okay, well, let's, yeah. On the passage of the bill, the yeas are 40, the nays are 13, and this bill, having received requisite constitutional majority, is therefore adopted. Chair recognizes Senator from the 46th.
Thank you, Mr. President. I move the Senate stand adjourned until 10 o'clock a.m.
No, not that one.
Well, I'll take it back.
Chair recognizes Senator from the 46th.
Before we adjourn, Mr. President, I'd move the Senate immediately transmit House Bill 159 to the House.
Is there objection? Without objection, the Senate has moved the bill out on the 5th legislative day in record pace. I appreciate the Senate for all the hard work on this very, very important issue of child welfare, and I appreciate also the debate in which ensued here today on the Senate floor and the respect that was shown by each individual. The Secretary has a resolution we'd like to read.
Senate Resolution 594 by Senator Anderson of the 43rd and others, a resolution committing and congratulating Dorothy Hutchinson for other purposes. That concludes the order.
Is there objection to adoption of the resolution? The chair is none. The resolution is adopted. Chair now recognizes Senator from the 46th, the Majority Leader.
Thank you, Mr. President. Move that the Senate stand adjourned until Friday morning, January 19th at 10 a.m.
Read the announcements.
Rules will meet upon adjournment standing committee only in 450 of the Capitol. Judiciary will meet at 4 p.m. in 307 of COB. That concludes the order.
Chair recognizes Senator from the 4th for an announcement.
Ladies and gentlemen, of course, we had to cancel the appropriations hearing yesterday. Those will not be rescheduled. The House will start their subcommittee hearings on Monday, and we'll be having our subcommittee hearings as well as time moves on. On your desk today, though, I wanted to point out is a listing of the appropriations items in the governor's proposal, both the amended and general budget. It's a very useful tool for you in writing a column or speaking, or if you want to know where something is from. So I'd suggest you take that with you, and if we can answer any questions, please let us know. Thank you, Mr. President.
Chair recognizes Senator from the 39th for an announcement. 39th, you wish to be recognized for an announcement? Well, as a newly elected senator, at least you were at your seat, unlike the senator from the 17th. So be aware that, oh, it was that by accident, senator from the 34th. Senator from the 34th apologizes. Are there any other announcements? The Majority Leader has moved that we stand adjourned till 10 a.m. tomorrow morning. All those in favor will say aye. All those opposed, no. The ayes clearly have it. We stand adjourned.